Hello, and welcome to today's webinar about managing somebody else's money, what your best practices are. My name is Lucy Gerland. I am a caregiver specialist with the Fairfax Area Agency on Aging. You should have received an email this morning with the speaker's slides, so you will have them for reference in the future. It is not necessary for you to have those open during the presentation. We will be able to see those. You can ask a question at any time during today's presentation by typing it into the question box on your panel. Today's presentation is being recorded, and the recording will be sent to all registrants by early next week. There will be a brief survey as you sign out, so please help us by giving us your thoughts. And now it is my great pleasure to introduce today's speaker, Tom West. Tom is a partner at SEIA, and he leads a team of financial professionals who offer robust financial planning and investment management services that emphasize cash flows in all stages of retirement. The firm offers life care affordability planning, helping clients secure and protect wealth when planning for their most helpful outcome when facing a health care or housing uncertainty due to disability, illness, or death. Tom has a lot of community service in the aging and disability area, and he has gotten lots of recognition from a variety of nonprofits and local government groups. He's currently the board chair of Goodwin House at Home in Alexandria, Virginia, and he serves on the corporate board of Goodwin House as well as on the board of Insight Memory Care Center in Fairfax, Virginia. So over the years that I've been working with Tom, I have found him to be just very involved in the entire aging community, as well as extremely knowledgeable in the topic of financial well-being. And he's going to share his extreme knowledge of that with us today. So Tom?
Good afternoon, everybody, and thanks, Lucy. You always make me feel awesome at the beginning of these presentations.
You are awesome.
Stop. So for everybody else, let's talk about what our agenda is today. I've got maybe 40, 50 minutes tops of prepared comments about managing somebody else's money. This is a topic that speaks to me on a number of different levels. From a professional standpoint, a lot of the things that we do is guide families when they're stewarding money for somebody else that might be challenged with uncertainties related to chronic illness or disability or whatnot. So I think that the topic that we're going through today, we have a whole lot of experience with, and I'm really happy to be able to share it with Area Agency on Aging and whatnot. One of the things that Lucy and I are pretty good at is sort of managing questions as they come up. So we chatted a little bit beforehand, and in the event that anybody has questions, I'm looking at this camera here, but there's that chat box that you can type stuff in. Lucy knows that she's got license to interrupt me if there's something that's on topic. And if we feel like we might be running a little bit long, perhaps I'll defer some questions to the end. But I want to encourage everybody that if you've got a question that's sort of germane to the slide or the topic that we're on, don't hesitate. So moving into the slides, managing somebody else's money. We try to come up with as many tips as we can in terms of accepting fiduciary responsibility. And one of the things that I wanted to start with was, what is the definition of a fiduciary? A lot of times fiduciary is a word to describe a standard of care that you hear in the financial services industry. And when you're a fiduciary as a professional in the financial services industry, think that the standard of care is to always do something that is in the absolute best interest of your client. And that's the highest standard of care that we have in the financial services industry. And that's discrete from something that might just be a suitable standard of care, meaning I might recommend something that is okay for a family, but it might pay me a little bit more, but it might not be the absolute best. So a lot of times when people are thinking about working with the financial services industry, this word fiduciary comes up quite a bit, and it has to do with standard of care. But for today's meeting on the topic, we're talking about What does a fiduciary mean for you? For families that might have somebody needing to step into a role to assume stewardship over some money, over some property of somebody else. And we'll talk about that in a whole lot more detail, what it means for individuals. So for individuals, there's basically 4 basic duties of a fiduciary, and they're pretty straightforward. And we'll go into these in a little bit more detail. That if you're acting as a fiduciary for somebody else through a power of attorney or as a trustee, for example, your job, your standard is to only act in the best interest of that other person. Another duty is to manage money and property very carefully. You can't be sloppy with it. There's a duty to make sure that you're intentional and well-reasoned in the actions that you're taking. Number 3, you're responsible for keeping money and property separate from your own money and property, making sure that there isn't any commingling. That's a standard that's sort of universally accepted and legally enforced as well. And then the last one is to keep good records. One of the things that is true in the legal system, whenever there's a question about whether or not somebody acted in a conflict of interest for maybe somebody that was less able to manage their own financial situations, if there's ever any questions that come up, keeping good records about what happened, why a particular decision was made, what the outcome was, how you monitor it, that's actually something that is a duty of a fiduciary. And whenever I'm giving guidance to groups or to families that have to step into the role of being a trustee or a power of attorney, these 4 things are sort of top of mind. There are different kinds of fiduciaries. For purposes of today, we're talking about non-professionals and family members a lot of times assuming the role of a steward or a fiduciary that are responsible for managing other people's money. And the most typical one that we see is somebody who's named as an agent in a power of attorney or a durable power of attorney. Remember, a power of attorney is a legal document that basically can name a successor decision maker to act as if they were the less able decision maker themselves, like to slide into their shoes. If my wife was using, for example, a power of attorney to act as my agent, effectively legally what she's doing is she's acting as if she was me. You can also be a fiduciary if you're named as a trustee under a revocable living trust, sometimes other trusts as well. But for today's discussion, we're going to be talking about being a trustee under a revocable living trust. And that's going to have a little bit different of ways to think about the standard of care. But effectively, the best place to look for instructions on how to serve as a fiduciary if you're named as a trustee is to read the trust. There are a lot of times, depending on attorneys that are drafting it, some specific instructions about how money and property is to be handled and managed. And that's going to be something that might be a little bit more directive than an agent through a power of attorney, which is a broader definition of what the scope of decisions that they might be able to make than somebody who's a trustee that might have a more narrow and more specific set of instructions on how to manage money. I'll also talk about representative payees. Those are people that help manage monies that are coming in from the government, like Social Security or Veteran Affairs fiduciaries. That's technically a separate category of a fiduciary who is managing income coming from government entities. And then lastly, the court sometimes has to appoint a guardian or a conservator. Guardians typically are people that are appointed to make decisions over the person, about healthcare and things like that. Conservators typically track about money and property, but those are all court-appointed nominations if there is an absence of legal documents to basically put somebody in that position. So those are the different kinds of fiduciaries, and my expectation is a lot of people tuning in today are in those first 2 categories with maybe a smaller set that might be a guardian or a conservator for somebody else. So this next slide that I've got, let's go into act only in the best interest of another. Let's go into that in a little bit more detail. How are you sure that you're doing what you're supposed to be doing? Well, you know, the really obvious one that sometimes people skip is, well, why don't you pull out the legal document that names you as a fiduciary, and if it's a power of attorney or a trust, to be named as an agent or a trustee. Why don't you read it first and determine a few things. One, confirm that you are in charge of a set of decisions. Two, understand when it becomes effective. Sometimes agents in powers of attorney only become nominated for this responsibility after there is an impairment, maybe perhaps a cognitive impairment like dementia on the part of the person that drafted the or that signed the document. Sometimes in trusts, for example, people have full authority to do things in the trust right from the jump, and there might not be a trigger. Sometimes people have to resign their role as a trustee for somebody else to assume responsibility as a successor. But in all cases, on my third bullet, we've got to avoid conflicts of interest, making sure that you're not unduly benefiting from any of the decisions that you're supposed to be making on behalf of somebody else. Avoid changing plans for giving away money or property. Whatever the intent was on how money is supposed to be managed and stewarded, it's going to be your responsibility to stick with that particular plan. And don't pay yourself for taking this responsibility unless the document specifically and explicitly allows for you to do that. And that's sort of some summary and some quick points on acting only in the best interest of another, which was the first of our fiduciary duties. The second fiduciary duty, managing money or property very carefully. I'm going to expand on this during the latter part of our discussion today, but for a first pass, well, listing out all of the money, all of the property, and all of the debts, and just making sure that you're pretty organized in terms of what assets that you might be responsible for, what debts you might be responsible for. That's probably the first step in doing things carefully, is doing a thorough inventory of everything. If there's pieces of real estate or cars or houses or whatnot, it is your responsibility to have that protected. If there is a need to continue or to get insurance on a piece of property, that's going to be one of the responsibilities that you've got as an agent or a trustee. Invest money carefully, and I'll give you some good tips in the latter part of our discussion today about smart ways to think about that. But certainly pay bills, manage expenses, and there's also a duty, we think, in terms of managing money carefully, to make sure that the document that authorizes you to be able to make these decisions is accepted, for example, in different financial institutions. And I can take some questions on this at the end, but the legal document that gives you authorization to make property and money decisions for somebody else is only as good as it being honored by a financial institution, for example. So make sure that you understand what the steps are to make sure that that document that names you as an authority is actually accepted. And if it's not, what are some different ways around that? Sometimes financial institutions have some of their own forms that they want to sign discrete from the power of attorney that you might hold. And we can talk about that in questions as we need it. Duty number 4, keep money and property separate. This is pretty straightforward. Separate means don't commingle your money and the person's money that you're managing. Avoid joint accounts. Keep money and property titled appropriately. It's usually a bad idea to change the title of how a house or how a brokerage account, for example, is titled. Generally speaking, good rule of thumb is keep things sort of the way they are unless there's extreme circumstances. And also, keep money or property separate. Learn yourself how to sign as an agent or as a trustee. If my wife, for example, is serving as a trustee for money in my trust, when she's signing as somebody that's authorized to do that, she would sign it Beth West, trustee of the Tom West Revocable Trust, dated such and such. Knowing that you've got a sign to indicate to whoever is reviewing that signature, that permission, that you're playing a particular legal role. Make sure that you're not just signing it just with your own name without indicating the special power and authority that you've got. And this last piece, this last duty, keeping good records. Well, just be thorough. Keep a list of everything received and everything spent. Keep receipts, even the tiny ones. I think that the more thorough the paper trail is for any decisions that you've made along the way, the higher the likelihood is there won't be any problems and in case anybody comes back and second guesses any of the actions that you've taken. I think a good rule of thumb is to avoid cash transactions because they don't leave a paper trail. And the idea is if you're able to track expenses and whatnot from credits and debits out of a bank account or a credit card or something like that, or even personal checks, that's a whole lot better than using cash, which is a lot more difficult to track. And again, if you're getting paid to take on this role, be sure that the charge that you're having is reasonable. There's different rules of thumb, but probably taking a modest hourly charge is typically sort of the best way that I've seen things done. But if you're getting paid, make sure that the charge that you're having is reasonable. And again, back to the previous slide, it's explicitly allowed. All right.
Okay, Tom.
Let me stop there with questions.
Yeah, we do have a question. Why do you not recommend joint accounts?
Well, a joint account, for example, let's use me and my wife Beth as an example. If I already have a joint account with my wife, all right, and we have like a joint checking account, she already has the ability to make decisions on that account, to take all the money out of the account, to move money around in the account because she's a joint owner. What that joint ownership, though, it shouldn't be used as a replacement for a power of attorney. So let's say, for example, that I inherited money from my parents and it's sitting in an account that's just titled just to me. And Beth is serving as my durable power of attorney because I might have dementia. It is better for her to use the power of attorney to act as an agent in that account than to change the title of that account from an individual Tom account to a joint account. Because what legally she would be doing if she's doing that joint account is she's effectively giving herself 50% of control of the account as if it were hers, but that's not the way it was originally titled. Sometimes older generations will use joint accounts with their kids as sort of a more convenient way to share some responsibility and whatnot. But I always think it's best practice to have money titled as it's supposed to be, and then to have a successor decision maker use a power of attorney or use a trust nomination in a revocable trust to play that role. Lucy, another way to think about it is the role that you're playing is very clear when you're using a power of attorney. If you use a joint account, then it kind of looks like, in my example with my wife, it kind of looks like she's made herself a co-owner of a piece of property that she wasn't a co-owner before. Somebody could say, well, listen, that might look like a gift. Maybe Tom wanted to have this individual account go to his kids or go to a charity. And if it goes into a joint account, it sort of changes the arrangement that titling was doing. So as a rule of thumb, you always want to use a legal authorization as sort of the best practice. I typically don't have too much heartburn if you have seniors having a small, joint account with like a checking account just for convenience with a child. But I'll share with you, I don't think that's best practice. And I think that shortcut sometimes runs into more trouble than if an adult child would be using a power of attorney instead. But thank you for that question. It was an important one.
Yeah, I think it's interesting. I don't know if you see this a lot. I know we had this, we have this situation happening in our family. The joint account owner is also the financial power of attorney. But if a person, I just got a follow-up question from somebody else. So, this is possibly a common thing.
No, it's common.
Yeah, if you've already done this joint account situation, what do you do about it?
Well, I think it depends on a few things, and the fairest answer, which might be the least satisfying, is I think a little bit depends on what the family and the financial circumstances are. So if I'm, for example, an only child, okay, The idea of having me on as a joint account holder for checking for my mom and dad, just in case something happens, if you sort of play out what's the worst thing that happens with that particular checking account, probably not much. On the other hand, from an estate planning standpoint, let's say that I've got a brother, and the brother and I don't get along, and my mom and dad don't want everybody to be treated evenly. Or excuse me, they want our family, or me and my brother, to be treated evenly in their estate plans and in their will. But let's say, for example, it's not just the checking account. Let's say they put me on as a joint owner in their brokerage account. When my mom and dad die, and if I'm on, or it's my mom, for example, and I'm on as a joint owner, I'm going to get as a remainderman all of the money in that account, and it doesn't matter what the will says. The will would just divide everything else. And sometimes for larger accounts, the use of joint ownership complicates the intent of estate plans when people die. So I would have to say it depends a little bit on the circumstance. If there's small accounts for convenience, it's probably not a big deal. But broadly speaking, you want to use a power of attorney. That's the reason that the state of Virginia, for example, put that in their state statutes, is because they want you to use that. And any other sort of approach with the joint, ownership is whatnot, is sort of a poor man's way to do it. It just runs some different risks. So it's not exactly the most satisfying answer. I have had circumstances where we've recommended that a joint ownership of a brokerage account or a house, for example, like that, if that goes against the intent of the estate plan, then absolutely I go back and change it. We retitle it back to sometimes a senior, and we use a power of attorney or a trust nomination to make sure that somebody else can steward the money effectively.
Okay, thank you. Because you just answered the third question. If you're already in that situation, what do you do?
Yeah,
All right, moving on. Thank you.
Sure. All right. So so this is a slide where part of the reason that this was a favorite topic of mine, Lucy, is I think that there's the nuts and bolts and the legal stuff in terms of fiduciary and what roles and responsibilities you've got, which I've covered. But I also want to put some attention into, like, how do you really make decisions? And, aside from all the legal stuff, I haven't done this before. The person whose money I'm taking care of, they might be afraid or vulnerable, or they might not be able to communicate. Maybe not everybody's on the same page. How do you really make decisions? And I always like to frame it this way. After there's a death or a disability or a profound financial loss, maybe somebody dies and income changes around quite a bit, or there's a big windfall. You're serving as a steward for somebody else's money, and somebody else dies and a whole bunch of new money comes in, and how do you make decisions with all of this? I put this Eisenhower quote up there because I think it's really telling. Plans are nothing, but planning is everything. And what I want to introduce for the rest of the session is, what's the process that we use from a planning standpoint to best make decisions about other people's money? Let's also talk a little bit about the realities and the challenges of making money decisions for somebody else, particularly if there are healthcare expenses involved. How do you make decisions about money when you don't know how long somebody's going to live? How do you make decisions about money when you don't know how much help they need that we might need to pay out of pocket for? And I think it's appropriate for all of us to recognize that there's a tendency to procrastinate and to not do anything and to not make any mistakes until better information presents itself. We're serving right now a client where we're working with an adult daughter and an older mother who is losing her ability to be independent in her home. And right now we're trying to talk them through, a period where they don't want to do anything. They're kind of frozen. Because they're waiting for something really bad to happen, so there's no ambiguity about what choice they have. We want to take a different approach, and what are the kind of proactive things that we can do that protect us against this tendency to procrastinate in a way that meets the fiduciary standard that we talked about before. There's also some realities about, these powers of attorney or trustees. And just because you have a piece of paper doesn't mean that everybody, particularly in the family, is happy about it or accepts it. If you are now the financial steward of the house, if you've got siblings or other family members, or maybe even other parent, does everybody accept your authority? because the paper might say so, but if you've got other voices in the family that have influence, that might not be an easy thing to be able to actually, use the authority. Do you have realistic expectations about what might be coming down the road? And, in my experience, this is a pretty stressful responsibility for a lot of people. It's not just something people just pick up lightly. It's always appropriate to think about, are there circumstances where, a family member that's serving as a fiduciary, when can they delegate and when can they ask for help? And there's always a balance between, listen, I'm the one that mom named as the power of attorney, and she did that for a reason, but I really don't know what to do, and I haven't done this before, but it is my responsibility, and I'm the one that's supposed to be in control. How do I actually work through that particular dilemma? And that's what we're going to talk about for a good part of the rest of our time. I think the first way to think about it is, what decisions need to be made right now? I want you to think of this think about like at a calendar. Okay, you've got what kind of due dates that, regardless of what you might want to do or feel like doing, the calendar says you got to do a few things. So one of the things, I'm going to jump ahead a slide. What are the time sensitive things that have to happen and when? Well, you got to pay your taxes. The April 15th deadline is appropriate, so that's going to be something. There might be mandatory payments that have to come out at particular due dates on bills. You're really responsible for making sure that those things are done in a timely way. Sometimes people forget that if there are retirement accounts that are owned by somebody older than 70 and a half, you've got to take required minimum distributions. And there's a penalty if you don't take required minimum distributions. So those are things that you have to be really, really aware of from a time standpoint about what process do you use to make sure that the decisions that you have to make. I'll go on this other piece. I always say as at the front end of a journey as a fiduciary, as a trustee or a power of attorney, maybe think about breaking, a long journey into small steps. I always think sometimes it's appropriate to try to identify a qualified guide who in perhaps your life, your personal life, might have played this role before. Are there folks in your family? Are there folks in your faith community or friends or whatnot that have actually served as a power of attorney and a trustee that can give some guidance about, things they did that worked well and mistakes to avoid? I also think, based on the different fiduciary duties we had in a previous slide, list all of your responsibilities and, make sure that you act on them as required. And in a future slide, we'll talk about sometimes you have to act even though you're not sure what to do. I also want to be, conscious of, be patient with yourself and with others. If you haven't done this before, don't beat yourself too much up. I think that the idea of asking for help and doing things like tuning into a webinar like this, that's a good place to start. And I always encourage, when in doubt, continue to get more information. But we want to be mindful of this last bullet. Make conservative decisions, but do make them. Sometimes I see that people that are uncertain or uncomfortable in this fiduciary role, that they spend a whole lot of time gathering information and thinking about options, but never making decisions. You want to make sure that if there's a particular decision that needs to be made, that it is done in a timely fashion. And I'll talk about how to identify those in a second. But let's make sure our tendency is to procrastinate when we're not sure. So you've got to be front and center about knowing, listen, past a certain point of time, we might have to make a decision to sell a house, or we might have to make a decision to pull from one bucket of money versus another bucket of money. So be aware that these decisions, that's part of the reason that you were elected, you were nominated for this particular role, is faith in your ability to make those decisions. So, what if I'm stuck? Well, if you don't know what decision to make or when to make it, where do you start? And I think that this last part, is a good mental framework about sort of best practices and decision making that for all pieces of even my personal life, I go back to this particular method, and it always helps. So I hope that the value is imparted with what I'm about to go through. If you look at all sorts of different disciplines, whether they are in government, in medicine, in law, in finance, and whatnot, there's pretty much agreement about optimal decision-making processes, and they always look like this, which is the first step is right there on the top. Organize all of the information that you need. And, and I'll identify these and I'll go around in a circle. Organize all the information that you need, evaluate all your different options and choices, formalize a plan, meaning decide which of those particular choices that you're going to make and why, execute on that, actually make the decision, and then monitor how well it's going to go back to the top and to reorganize from your information again. And I want everybody to look at this. This is sort of an always rotating pattern. There isn't a point where somebody just stops at one. And I think another piece that's important is people might want to immediately make a decision and execute on something, but they might have skipped a step where they don't have all the information they need, or they've skipped the step of identifying all the different choices and whatnot. The best decisions, we think, that when you're playing this role of a fiduciary for somebody else, is always going to touch on all of these things in their right turn. So get organized. I talked about this a little bit in a previous slide. Make a balance sheet. This is a list of all the assets and all the debts, and write it down. I do think that there is a benefit of actually writing it down, in your own handwriting or on your own computer, and not just have a file that is a cumulative pile of information. I actually think that the effort of organizing something in the own way to look at it, sometimes is really helpful, and sometimes can empower people that might not be confident in moving forward. I always talk about organizing cash flow. What are we spending? What are we earning? Is there more going out than is coming in? How much? Under what circumstances? And it's also important to identify in the cash flow situation, what are items that can change, like the idea that if somebody needs help and they're receiving a little bit of help at home, but maybe they might need more down the road, or maybe they need to move to an assisted living or something. Here's items in our cash flow and our spending that could change, and here's things that won't change. I know that as long as dad's alive, he's going to be getting his federal pension and his Social Security. That's really not going to change. As long as he's around and I'm responsible for managing his stuff, those are things that aren't going to change. And when you're doing this organization, identify areas that can be simplified or consolidated. I'll give you an example. So part of my professional role sometimes, I'm something called an accredited investment fiduciary. That's one of the professional standards of care that gives some guidance in terms of best things to do when you're in the wealth management business. The first thing that I do and my team does is look for areas that can be simplified or consolidated. If there's money in 25 different places for any of a number of different reasons, I always want to know, is that the way that you would build it if you're starting from scratch? Because sometimes it's just too complicated to have that many different financial institutions or these different accounts or whatnot. Are there areas that could be consolidated as a potential action just to make your own life easier and to make that reporting requirement that some of these documents force a little bit easier? Evaluate different options based on identified goals. I mean, sometimes people are put in this position because, previous decision maker died, and maybe, income is different when a deceased spouse is no longer getting paid a pension or Social Security. What are the different options to be able to make sure that a survivor has their most income? And another example would be a disability or illness. What are the different options to pay for quality care, to pay for standard of living or whatnot? Is it staying at home? Is it making a move? Is it moving in with you? Is it like whatever it ends up being? Identify all of the different options before you skip ahead to actually make a decision. Just make sure that you've got all your choices sort of lined up. Formalize is the part of the step, Lucy, that basically says, I think it's important to try to say what you're going to try to do before you do it. You set a goal, like I want to make sure that mom gets taken care of as much as possible at the highest quality of clinical and therapeutic care if she's ill, and she stays socialized, and that she stays around me if I'm living here in Fairfax County. Formalizing that as a goal and making some decisions that all of the different decisions that we're making about money or property are going to be attendant to that goal. And you start making some itemization of all of the different things that really need to happen. and identify what outcomes you might be able to financially weather. Maybe we need to not spend quite as much on some particular category early, and identifying a little bit of where the risk is. Those are all things on sort of formalizing a plan. Imagine that if somebody were to come to you in the role that you're playing later and say, hey, how come you decided to do this? If you have all the information organized, step one, you've evaluated a bunch of different choices, step two, and you've formalized a particular decision. This is what I'm going to try to do based on the goal, and this is my logic behind it. Just having those 3 steps a lot of times can assuage a lot of doubts. It can certainly lower liability if people are doubting you and your role, and those things are real important. But you want to actually have a plan that is, on my next thesis, actually executed. Financial solutions should be customized to whatever the new goals are. And I think that does a previous portfolio allocation work? Does a previous cash flow still work? Does a previous liquid reserve of cash still work? Sorry about the sort of the funny layout here. But remember, sometimes after people make a decision in this new fiduciary role, sometimes they forget that they can't just leave the rest of the money and the rest of the accounts untouched, because the allocation, that the money in different categories or stocks and bonds and IRAs and things, that the way that they've been set up, that might not be appropriate for your new situation. If you change the job of your money in this fiduciary process, then I think that it's important and a responsibility to you to make sure that all of the different accounts, for example, are set up in a way that serve the priority that you're moving on. And I always try to ask it this way: what is the job of the money on the bottom? And sometimes that can be pretty easy to understand. The job of all of these different accounts is, I need $7,000 net of fees and net of taxes to go into my checking account to pay bills at the end of every month. And I like having that being as simple as possible. This is the job of the money, and it needs to last, and there needs to be some appropriate attention put towards the legacy priorities of a parent or a spouse. But what's the job of the money? I always like the idea of writing that out explicitly when I can. And the other piece too, I'll just make a quick mention. There's this concept in the financial services industry about money being managed for other people, if that is something that's appropriate, on a discretionary or a non-discretionary basis. And these might be new words for people in the audience, but just to give you an idea, if you are working with somebody in the financial services industry that are managing money on a discretionary basis, what that means is you or the person whose money that you're managing are giving a financial services institution or professional the discretion to do what they think is best with the money that's being managed. Okay, I want to remind everybody that it's your responsibility as a fiduciary that a third-party financial person is doing the right thing if you're delegating discretion. That's part of the reason I'm saying just make sure everybody's on the same page about what the job of the money is. There's also approaches where working with financial institutions can be non-discretionary, meaning I'm not giving the financial institution discretion to do different stuff with the money. I want to make sure that me as a financial decision maker has sort of line item veto on all of the individual transactions that could happen, all of the tax implications, all of the way that money is moving in and out of the account. And I'm not delegating all of the responsibility, for example, for an investment portfolio to a financial institution. I mention this just because not a lot of times people think that maybe the way they relate to a financial services institution, sometimes there's a choice where you don't necessarily have to delegate all responsibility in a discretionary thing. But if you do, make sure that it's appropriate for you. And then this last piece, on the monitor standpoint, don't let go of the rudder. The reason I have this slide on here is because sometimes when people assume a new financial responsibility, they kind of make one flurry of decisions and then they just sort of let things slide. It's stressful, it's a lot of work, and after they do some initial setting up, they kind of phone it in a little bit in terms of this particular process. I want to remind everybody that is serving in this role, as part of your responsibility is to make sure things continue to go according to plan. That's part of what the document's saying that you're supposed to be doing. So figure out what the monitoring function is. What are changes that might be happening to the person whose money we're managing, whether there's a change in illness, a change in expenses to be able to take care of somebody and whatnot, and make sure that the decisions that you make in the beginning continue to be the right decisions as time goes on, because a lot of times people need to course correct. What happens if there is new money that comes into the household? What happens if the stock market goes down? What happens if the tax situation changes? You want to make sure that your monitoring function, what are the things that might be changing, so that when you go back to the top of our process to organize again, that you're as up to date as possible. And commit to a timeline to reorganize and start the process again. I think annually is probably a pretty good default, or certainly when something really big and significant changes. But I think that if fiduciaries and families are at least taking a look annually at recasting everything and making sure they understand how to organize, evaluate, formalize, execute, and whatnot, I think that they're going to be better served for it. And the last piece, just for a slide or two, if you're using a financial advisor, what's the best way to use them? Well, I want you to think there's two different ways to use somebody in the financial services industry. I would say proactively. Could you use them to put together a plan that envisions, security and success under whatever your goals and circumstances are, and you do that in the beginning, or reactively, whenever anything changes, you bring in a financial professional to help you muck through whatever the new circumstances in. Now, as a planner, I'm obviously going to err on the side of saying it's probably best practice that if you're going to use somebody in the financial services industry, do it more proactively than reactively. But if there's a circumstance that needs a whole lot of attention, along with your tax and your legal professional, reactively might be the best way to go, and just to identify who is the right person to serve that. It might not be whoever is your financial advisor right now. And then the only other piece that I'll mention, a financial advisor can help align the behavior and decisions that you've got with your goals. I think sometimes when people are managing money for other people, it's very difficult to, on their own, establish a new hierarchy of priorities. Maybe it used to be that, grandma and grandpa's priority was to maximize an inheritance to kids and grandkids. But that was before they really thought about dementia. Being able to realign all of the different priorities and make sure that all of the different decisions that need to be made are attendant to those new priorities. Sometimes having a third party like that can help. We can help qualify subjective priorities or quantify benchmarks. We need to make sure that the portfolio is able to do, my example from earlier, $7,000 a month, and how are you able to do that very precisely? Those are things that a financial advisor might be able to help out with as well. Not everybody needs a financial advisor to help with this. Sometimes people that, if they're following those different steps, organizing, evaluating all the different options, executing and whatnot, those are things that sometimes people can do themselves. I just want to make sure that, if you're looking for qualified guides in the legal or the tax or the financial institutions, this is sort of a good way to identify somebody that might be a qualified guide for you. And I'm going to leave this as sort of my last slide. I think that, again, if people that are in the position of having to make financial decisions for others were pretty diligent in doing things this way, at least annually, I think that a lot of pressure is relieved, and a lot of outcomes in terms of the responsibilities that you've been given are so much more likely to be achieved. So with that, that's really the last slide that I've got on the presentation, and it looks like I've got a good 15 minutes left, Lucy, for any questions for you or anybody in the audience.
Yes, I do have a few more questions. How do I get my parents to stop being so tight about their money and talk to me and set these plans in motion?
Oh, that's a good question.
Like that one?
I too have parents, so I know what you're talking about. I think that there's basically 2 or 3 different ways, and some of this has to do with the role and the roles that you have in your family right now. The first thing I would probably say is, appreciate how hard this is for mom and dad, where they've traditionally seen themselves in a particular relationship with each other and with you and with other people in the family. And, there's a lot of resistance to those things changing because, if I start letting you in, I'm less independent. I might not be the same person that I was before. I might not have the same roles and responsibilities. So I would be sensitive to what some of the soft feelings are behind resistance. So I'd say that initially. I think that the next thing is going to be, I always think it's appropriate to sort of be realistic, which is, in the event that you become less able to make these decisions for yourself, one way or the other, somebody else is going to be having to make these decisions for you until the point in time that you pass away. Like, that's just a fact. If you can't manage this stuff yourself, there are a number of different processes that have to happen. And a good example would be if you don't have any of these documents in place, or you're not forthcoming about the information about what's in them. Well, the state of Virginia, for example, they've got a process of what happens. It's a process called guardianship and conservatorship. This is what it looks like. You can do a quick Google search on what guardianship or conservatorship looks like. And sometimes people respond if they recognize that that's kind of their default plan. If you don't have all these powers of attorney and whatnot in place, the default plan is whatever. It's like dying without a will. The state has a default plan for you. And even though you don't want to make a plan because you don't want to face that particular reality, there's still a process that's the default. It sounded like the question was coming from a place that maybe you already had the power of attorney and you just don't have any of the information, or you don't have mom and dad necessarily as a willing participant in the conversation. I think that there's also something to be said for, expressing some vulnerability yourself, which is, I'm scared that I'm not going to make the right decisions for you. I'm scared that I don't know the priorities that you have about your money and how you want things to do. And with this document that you've given me, if I can't communicate with you as well as I can communicate with you right now, I'm worried that I'm going to do something that isn't what you would want me to do. And can you help me manage that? Or if you can't help me manage that, is there somebody else that you want to do this instead of me? I do think every now and then some of those expressions of vulnerability and worry about your own role, if you express that in the right way, sometimes that gets some traction. And then the last thing is, sometimes it's not the message, it's the messenger. I've had a lot of times where, I have adult sons and daughters, or even spouses sometimes, have these conversations where you're just knocking heads with somebody that, I'm not telling you anything and I'm not doing anything and I'm hunkering down and I'm locking down. Sometimes it's the messenger, where if you have a third party, whether it's a friend or another professional that says, look, George, you're going to have to do this. Like, okay, we'll do it. And I played that role myself in a lot of family conversations, which is, I'm not saying anything different than what a family's saying among themselves. It's somebody that isn't in the family that is able to be perceived as somebody that is third party and objective, and not a child that I might still be imagining is in grade school. So those are maybe some different approaches that might work. I hope there's something in there that works for you. But thank you. That's a great question and a really realistic one.
Yeah, and I think those are great approaches. And as you were speaking, I was thinking this would work beyond the financial realm, like when you're trying to get somebody to make advanced directives.
Absolutely. Right.
People often, right? Nobody wants to talk about that. But if you use some of the approaches that you said, I'm worried that I may not make the decision that you would want to make.
Yeah, and I
So,
mean, and I'm glad you brought it up that way, Lucy, because that whole conversation that question gave us, it reminds us that this involves money, but it's not really about money. It's about people feeling vulnerable, about not wanting their independence taken away from them, about wanting to maintain a particular role or perceived role in a family. Like, those kinds of things are emotional. They've got some hair on them. And those are what a lot of times sort of derail, a lot of well-intended plans. I'd also, it's sitting here right in front of me to the person that asked the question, the idea of, I'm trying to invest some time in being the best power of attorney or trustee that I can be for you. And for example, even if you're using this presentation, the first thing that everybody says is organize all the information. And if mom and dad are being reticent about sharing anything, maybe the idea is, the information is going to come to me one of two ways. Either you're going to provide it, or something terrible is going to happen. I can't communicate with you, and it's my responsibility to go find it, whether it's from another financial institution or digging through your files. And, at that point, maybe I just want to play the role of a loving son or a daughter and to be there with you with whatever you're going through and not have to do this other dance of the responsibility that I've got with this document. But those are the two ways that the information is going to come to me to organize. And again, maybe you look for an opportunity to have somebody, not you, facilitate some of this. But when in doubt, go back to this process might help as well. And Lucy, just like you said, even these 5 steps could be used in medical or healthcare types of decisions as well.
Yep, that's something we all go through as caregivers, that's for sure. I have another question. What do you do if you are a power of attorney and a financial institution, such as a bank, is not recognizing your power of attorney? This says because your mother, loved one has dementia, but I think in general, also, banks don't recognize powers of attorney because they have their own. So maybe this is a 2-part question. In general, power of attorney, and is it different if somebody has dementia?
Okay, so this is an aggravating circumstance. So what I want you to imagine is whether it's a bank or an insurance company or a brokerage company, all of these different firms are effectively run by lawyers, and their decisions are basically based on what gets them sued the least. And the thing specifically that they're worried about is honoring a power of attorney that really wasn't appropriate. Meaning, let's say that Beth comes in with a power of attorney and says, take all Tom's money out, and the bank does that. And then my new wife, who I left Beth for, comes into the power of attorney after the fact and says, where's all the money? The bank doesn't want to be liable. So in a perfect world, the bank wants to make sure that the document is up to date. But what they really want is they want you to sign their own forms. So they've got a bunch of forms called an attorney in fact and whatnot. But in your question, you talked about, well, listen, I've got somebody with dementia. It's not like they can go and redo a bank form and give me authorization otherwise. It's useful to know that there was a law passed 2 or 3 years ago in Virginia that basically said, banks have to honor powers of attorney. And what I would do is I would start with sort of a Google search on how are banks, how can they be basically forced to recognize this particular document that in good faith people were putting together. It's certainly not going to go quickly. It's going to get locked up in somebody's legal department and whatnot. But if you can't go that route with sort of identifying this law that was passed and showing how it's the same as the power of attorney, and here's the documentation that mom's got dementia and whatnot, if that doesn't work, my recommendation would be go find a good elder law attorney to help agitate. There are a few financial institutions that I will share with you are just an excruciating pain in the neck with this stuff. And the best practice is before dementia, which might not help you in this case, but before dementia, if I'm giving my son Jack, for example, authority as a power of attorney to act on my IRA, then the best practice is I fill out the attorney in fact form at the bank or at the brokerage house, which mirrors the legal document that I've created. And the logic at that time, if I'm trusting my son Jack to be making financial decisions for me if I'm disabled, then I'm probably going to be trusting him with the authority that I'm going to be giving him with this bank notification right from the jump. It is a problem, and I want to be real sober about that too. But I think that you've got some rights that are a little bit better spelled out in some recent in some recent law changes. So I don't think that the bank is on super firm financial ground. That doesn't mean that they're going to be real receptive, and that doesn't mean that it's going to be quick. That's part of the reason that you want to know when is it appropriate just to have an attorney start agitating on your behalf. Because if they don't honor it, remember, the only alternative to do something at that financial institution is to have a court-appointed guardian, which is public and expensive, or to sue them. Those are the two ways that you, if they're not accepting this power of attorney, those are the only two recourses if you have to get at those dollars. So that's not the greatest answer, but it's a realistic one, and hopefully there's some approach in there that'll work for you.
All right, thank you. Well, I will remind our attendees, if you have any last minute questions, hurry up and type them in. We're getting ready to wrap up here. And as you sign out, there will be a brief survey. So please take a moment to answer those questions and help us provide the things you want as webinar topics. We do have 2 more webinars scheduled for this year. Medicare 101 is coming up on Wednesday, October 9th, and Caregiver Considerations is coming up on Wednesday, November 6th. Tom, this was really fantastic and a really good way to approach this process here. And I want to thank you so much for giving us your time and your expertise.
Good.
And yes, look forward to speaking with you again. And if anybody needs to contact you, is your information in this in the slides that we sent out?
It should be on the slide deck. That's right. It's right here on that last page. I've got phone number and website on there if anybody needs to reach out. But thank you for mentioning that. And everybody, it's my pleasure to go through this with you. Good luck. If you're in this role, it's not easy, but I do hope some of these different approaches help you out. And thank you for having me, Lucy.
All right, and thank you again. Thanks everybody for attending. See you at our next webinar.
Bye-bye.
Bye.